Welcome to the Ask Junior Daily Judgment podcast. I'm Priya Sharma, and joining me today is Arjun Gupta.
Hello, everyone. We're excited to dive into today's important judgments. But before we begin, don't forget to like, subscribe, and share our podcast if you enjoy our daily legal breakdowns.
That's right. Your support helps us reach more listeners and continue providing in-depth analysis of the latest court decisions. Now let's get started with today's case. Anil Bhavarlal Jain and Anar versus the State of Maharashtra and Ors, decided by the Supreme Court of India.
This case revolves around a complex scenario involving a loan default, criminal charges, and the interplay between private settlements and public interest in financial crimes.
Let's break down the key facts. In 2013, Sun Infrastructure Pvt. Ltd., a company directed by Anil Bhavarlal Jain and another individual, obtained building permits and commencement certificates for specific land plots. In 2014, State Bank of India granted them a loan of Rs 50 crores secured by a mortgage on commercial land. While regular payments were made until 2017, the loan became a non-performing asset in November 2017 with an outstanding balance of 23.86 crores.
The bank initially sought recovery through the Debt Recovery Tribunal, DRT, where a settlement agreement was reached in December 2019 for Rs 15 crores. The company made an initial payment of Rs 20 lakhs, followed by the remaining 14.88 crores with interest, effectively closing the loan account through a one-time settlement. However, the bank subsequently filed a complaint with the Central Bureau of Investigation, CBI, alleging fund diversion from the loan account and unauthorized building plan modifications that devalued the collateral security.
The CBI registered an FIR in July 2020, charging the appellants under various sections of the Indian Penal Code, including Sections 409, Criminal Breach of Trust, 420, Cheating, and 120B, Criminal Conspiracy, along with provisions of the Prevention of Corruption Act. Following a charge sheet in December 2021, the appellants sought to quash the FIR through a petition to the High Court, but their petition was rejected. Consequently, they appealed to the Supreme Court.
The Supreme Court was tasked with addressing two crucial legal questions. Firstly, can criminal proceedings be quashed based on a settlement agreement reached before the Debt Recovery Tribunal? Secondly, can economic offenses involving financial institutions and public money be treated on par with private disputes when considering the quashing of criminal proceedings?
To understand the Supreme Court's reasoning, we need to delve into the concept of quashing criminal proceedings. In essence, it means to set aside or cancel a criminal case, effectively preventing it from moving forward.
The court, referencing the precedent set in Gian Singh v. State of Punjab, recognized that while certain criminal cases with a predominantly civil character may be quashed based on a compromise, this principle has clear limitations.
Imagine a situation where two neighbors have a property dispute. They might settle the dispute through a private agreement, thereby ending the legal case. However, the court emphasized that offenses involving moral turpitude, especially those under special statutes like the Prevention of Corruption Act, particularly when committed by public servants, cannot be nullified through private settlements.
Think about it like this. If a public official abuses their position for personal gain, simply settling with the victim wouldn't erase the crime or the potential harm to public trust. These offenses transcend private dispute resolution, involving broader public interests.
In analyzing economic offenses, the court referred to Parbhat Ahir v. State of Gujarat, establishing that these offenses fundamentally impact the state's financial and economic well-being.
It's crucial to understand that economic offenses don't just affect the parties involved. They have far-reaching consequences on the national economy. These offenses can erode public trust in financial institutions and destabilize the economic fabric of the country.
Drawing upon the case of R. Vasanthi Stanley, the court firmly held that serious economic offenses, or those potentially damaging the financial health of institutions, cannot be quashed solely based on grounds of delay or settlement. Doing so would undermine the fundamental principles of law and order.
Imagine a scenario where a bank loan is fraudulently obtained and misused, causing significant financial damage. Allowing the perpetrators to escape accountability simply because a settlement was reached would send a dangerous message about the sanctity of financial institutions and the rule of law.
The court also carefully considered the public interest dimension, emphasizing that banks handle public money and losses to banks directly impact the public exchequer. Involving the Prevention of Corruption Act, the court underscored that quashing proceedings would have broader ramifications beyond the immediate parties. Allowing such quashing would set a problematic precedent, potentially jeopardizing society's broader interests and the integrity of the financial system.
It's like a ripple effect. If we allow individuals to escape accountability for financial crimes simply because they reached a settlement with the victim, it could undermine public trust in financial institutions and encourage similar wrongdoing in the future.
Ultimately, the Supreme Court upheld the High Court's decision not to quash the criminal proceedings. The settlement reached before the DRT could not serve as grounds for quashing criminal proceedings, especially given the involvement of the Prevention of Corruption Act and the significant public interest implications.
This decision highlights the importance of upholding public interest in financial crimes and ensuring accountability for those who abuse their positions for personal gain. It sends a clear message that economic offenses, especially those impacting public institutions and the national economy, cannot be treated lightly.
The court recognized the bank's substantial losses of Rs 6.13 crores, which directly impacted the public exchequer. Quashing the offenses under the Prevention of Corruption Act would have severe consequences not just for the parties involved, but for society as a whole.
This case serves as a strong reminder that the justice system must protect the public interest, especially when dealing with economic offenses and public funds. It reinforces the principle that accountability cannot be bought through private settlements, particularly when broader societal interests are at stake.
And that wraps up our analysis of today's judgments. We hope you found our discussion informative and engaging.
Before we sign off, we'd like to remind our listeners once again to like, subscribe, and share our podcast. Your support means the world to us and helps us continue bringing you daily updates on the most important legal decisions.
Absolutely. And don't forget to tune in tomorrow for another exciting episode. Until then, this is Priya Sharma.
And Arjun Gupta signing off. Thanks for listening to the Ask Junior Daily Judgment Podcast.